recorded, so mics are live, and I'm going to start the webinar so people will start piling in at this moment. I'm first going to mute so that you don't hear me working with registrants as I do. The webinar is now live and attendees are now piling into the session.
Steve, just let me know when you think we have a critical mass and can go ahead and get started.
Let's give it just 30 more seconds, Chris.
Fair enough.
We seem to have a pretty good amount. Why don't we go ahead and get started?
Well, thank you all for joining us today. My name is Chris Lewis. I'm from the Maine Trial Lawyers Association. You're joining us today for a presentation on the rules of electronic court systems. We have a really great panel today. We're very pleased that everyone has been able to join us despite numerous power outages around the state today. Just a couple things before we get going. We have approximately 17 or so panelists. I would suggest if you go to the top right of your Zoom screen, you can put the set to speaker view, which will allow you to fully focus on the person speaking. As I said, we do have a large panel. We have Acting Chief Justice Mead, Justice Gorman, Justice Humphrey, Chief Justice Mullen from the Superior Court, Chief Judge French from the District Court. We have Erica Bristol from the Law Offices of Erica Bristol, Eric Wyckoff from Pierce Atwood, Maureen Boston from Pine Tree Legal Association. Joining us from the Maine Judicial Branch today, we have Catherine Wiltuck, Chris Oberg, Ann Jordan, Laura Perlman, Carolyn Hova, Joanna Davis, Betsy Boardman, Allison Gray, and Jonathan Huntington. We also have Will Richardson from Tyler Technologies joining us. So hopefully with that broad breadth of panelists, we can answer any questions that you may have. And to that end, I want to remind everybody that there have been previous presentations, the Maine eCourt presentation, and there will be subsequent presentations on more of the nuts and bolts of the e-filing process. If you missed any of these, they are posted, they are recorded, they're being posted on the Maine Trial Lawyers Association website, as well as the Maine Judicial Branch website. So if you missed something, you can watch it there. Today's presentation is being recorded also. If you want to go back and watch it later, or if your power goes out in the middle of it, don't panic. You'll always be able to watch it at a later date. We're going to be going through a number of different sections of the rules, and there may be a time for a question after each section, but most of the questions we're going to reserve until the end, and we'll pose those questions to the entire panel. At the bottom of your Zoom screen, you'll see a Q&A box. I see somebody's already posted a question there. That's a great chance to go to demonstrate the Q&A function. How does one go to speaker view on Android device? Unfortunately, I'm not sure. I think it's down at the bottom of your screen. But if you have a question for the panel, please post it there. I'll be monitoring those questions throughout the presentation, and we'll be posing those questions along with some questions that have been previously submitted to the panel at the end. Just a reminder, today is not a public comment on on the actual rules themselves. Those that time is past. These are the rules that have been implemented. It's really it's a time to understand how these rules are going to work, how they're going to affect your practice. And where the focus is going to be on the go live case types that are rolling out this fall. Juvenile and criminal are not rolling out this fall. There will be subsequent presentations dealing especially with juvenile and criminal. So if you're asking a question about one of those two areas and it doesn't get asked, it's just because this is not the presentation to address those questions. Again, there are going to be many more trainings. We're going to be having nuts and bolts trainings on the actual physically on how to do these things. There will be additional trainings similar to this one, where you'll get to ask additional questions, especially on those juvenile and criminal cases. So with that, I'd like to turn things over to Chief Mead. Chief, can you take it away?
Thank you. And first off, many thanks to Chris Lewis and Steve Prince and the MTLA for offering this platform to help us get the word out on this new initiative. We appreciate that. And a welcome extended to all of you. Thank you for your interest. We're all part of this, and we're delighted that you're on board here today. I have a few brief overview kind of comments before handing off to our panel of experts. But first, breaking news. Perhaps you heard that Tyler Technologies, the vendor for our case management system, reported a security breach a short time ago. The investigation is indicating that it was to their internal office systems only, their phones, their computers, and it doesn't affect the separate operating modules for the various customers around the country. But they are being very careful about looking into the breach and understanding all the ramifications of it. On September 25th, we issued a statement indicating that we would temporarily postpone the fall rollout of the main e-courts, given the unavailability of Tyler Technologies support services. We're not concerned about the security of our system, but when we hit the go button, we want to have the support services in place, and we're waiting for confirmation from Tyler that that is ready. So we issued another statement today, hot off the press. We're still awaiting that confirmation from Tyler that all is well. So the status right now is that our planned October startup date for limited case types in Bangor and the BCD continues to be on hold, okay? So I want to give a little background and context for the main rules for electronic court system. The RECS rules, it's a somewhat redundant acronym, but it's the best one that fits. I hope you've read them. This is all new. You really need to read them cover to cover. And they encompass really two categories. Part one are the access rules for case management system. These are rules 3 through 30, and part two consists of the rules for electronic filing and service. These are rules 31 through 40, and I want to address them separately. Part one, access rules for the case management system. These rules have been many years in the making. We took our first forays into access to electronic court records way back in 2005, and it has been a continuing project over the years that followed. The RECS CMS access rules are an attempt to strike a balance between two equally important objectives. One, to provide transparent and uncomplicated public access to court records, and two, protection of individuals from things like identity theft and threats to personal safety. It's been a years-long process during which we solicited comments from stakeholders and the public in general. We conducted public hearings, we posted drafts for comments, and have undertaken multiple revisions and study. To anyone who offered a comment during that process, understand every comment was seen and reviewed in this process. The final result, these access rules, strike what we believe to be an appropriate balance between the competing valid concerns that I mentioned. Now, the overarching policy behind all these rules, as announced by former Chief Justice Softly, was that electronic court records be accessible by the public, except as provided by laws, rules, and court orders. In our process, we identified every statute, rule, order, or other authoritative source of confidentiality and folded them into these rules, as well as some common sense provisions. We will undoubtedly gain additional insights and experience as we move forward into this new world, and the rules will be reevaluated from time to time, but we are confident that they will provide an appropriate platform to move forward. Part 2, the rules of electronic filing and service. These rules apply to court locations and case types where Odyssey and e-filing has been implemented. Currently, that would be the BCD and the limited case types in Bangor, subject to the temporary hold on those processes. Now, going forward, if there's any conflict between existing rules of court and the RECS rules, the RECS rules would govern in those places where e-filing is in place, and there will be a rule to confirm that in the future. We have a working group that is attempting to collect all the points of conflict between the court rules and the RECS rules, and we anticipate there will be significant modifications to the court rules when e-filing goes final for all case types and all locations, but that is probably a couple of years out at this point. So again, remember, please, the existing court rules will continue to govern where e-filing is not yet implemented. One additional point, our panelists will do their best to answer your questions, but it may be that we cannot offer definitive questions to all of your hypothetical questions. This is a learning process for us. It's an evolving process, so please be patient. And your questions will actually help us evolve and develop our new processes. It will be worth the effort. We are looking forward to working with you as we take this major step into the future. It's going to be good. With that said, at this point, I will hand off to Justice Humphrey, who will address some of these points in much greater detail. Justice Humphrey.
Thank you, Chief Justice Mead, and good afternoon, everyone. I'm going to give you a brief overview of the RECS rules structure, and then talk about the civil cases as they're applied with respect to these rules. On that panel, joining me will be Eric Wyckoff. We'll also be talking about access to juror information and some brief highlights with respect to the BCD and the implications of these rules on that particular case type. First, I would like to stress a few things that should be important. The RECS rules do not supplant the rules of procedure for civil, for criminal, for juvenile, family, or child protection. They are still alive and well and will exist alongside the RECS rules. The RECS rules are about access to the electronic court records, not process. And although public access to court records that is electronic court records, is restricted in certain instances by law, when public access is not controlled by law, the RECS rules will govern the public's access. I would also like to suggest and strongly recommend actually a careful review of RECS Rule 2A, which are the definitions that will be used throughout the rules. They're critical to your understanding of those rules. And typically, when we first started drafting these, we would define certain elements within the civil case part, then again within the criminal rule part, and we found inconsistencies. So we now have a single location that defines all of the terms throughout. So you will be referring back and forth to them from other elements of the rules that you choose to use. Rules and definitions in particular that I would direct your attention to are the definitions of accept, which refers to acceptance of an electronic court document by the clerk. the definition of accessible by the public only at a courthouse, the definition of accessibility by the public remotely, the definition of a court record and what it includes and what it does not include, the definition of electronic services, juror information, registry of actions. By the way, registry of actions is what we currently call, but will soon not, call dockets, and sealing and impounding, which is defined but also dealt with extensively in RECS rules 10 and 11. These rules apply to parties, persons, and entities filing or requesting access to electronic court records, to the court staff, the justices, the judges, the magistrates, and so forth. The rules do not apply to the county probate courts, and they do not apply to paper records and paper filings that existed on or before or were made before the implementation of the RECS rules. Now, structurally, as Chief Justice Mead has indicated, the rules are divided into two parts. Part 1 sets out the rules governing electronic court records access, and it includes Rule 3, which is a general access policy about the accessibility and filing of electronic records by access by the public, the parties, the attorneys. It deals with access to certain kinds of files, documents, and data, and types of access. That is, whether it's accessible remotely, wherever you happen to be with your laptop, or at a courthouse only, and it deals with the timing of access to those records. It also deals with Rule 4 involving civil cases, which Eric Wyckoff and I will be talking with you about soon. Rule 5 deals with criminal cases. That's not going to be part of today's presentation. Rule 6 deals with juvenile cases, also not part of today's presentation. Rule 8 deals with access to juror information, which I'll discuss in a short while. Rule 9 deals with procedures for accessing electronic court records remotely and at a courthouse. Rule 10 deals with sealing public court records, and Rule 11 deals with access to and unsealing impounded records. Chief Justice Mullen will discuss those in just a short while. Rounding out Part 1 are Rules 11 through 15, which deal with matters such as non-public cases, compiled aggregate and bulk data, access fees, and what happens when there are clerical errors. Part 2, which is Rules 31 through 40, deal with electronic filing and service. Rules 31 through 35 and 38 are rules regarding the electronic filing and service, and Chief Judge French and his panel will discuss those particular rules. Rule 31, 35, and 36 deal with additional points regarding filing and service, as well as, and Chief Justice Mullen, and his panel will discuss those again a little bit later in the presentation. If you're wondering why there are no rules 16 through 30 at all, we did on purpose. We're just trying to play with your minds. But seriously, those numbers are simply set aside in reserve as we come up with other great ideas suggested by you and others, and we need new rules. We've got the numbers waiting for them right now. So on to Rule 4, dealing with civil cases. And I'm going to turn it over to my co-panel member, Eric Wyckoff. Eric?
Thank you, Justice Humphrey. So I'm just going to provide a brief overview of what RECS Rule 4 provides regarding access to civil case records. The first part of the rule, it's Rule 4A, defines when court records become accessible to the public. And there's two pieces to that. It provides that court records will be accessible, that the court records will not become accessible by the public until first 3 business days after they're accepted by the court clerk of the filing, and then also after proof of service of process on at least one defendant. So those two items need to occur before a record becomes accessible to the public. The second part of the rule describes certain proceedings for which the civil court records are not accessible to the public. And those proceedings are mental health civil commitment proceedings, medical malpractice screening panel proceedings, sterilization proceedings, proceedings for extreme weapons protection orders, HIV/AIDS testing proceedings, and minor settlement proceedings. So in those proceedings, the civil court records are not accessible to the public. The third part of the rule, Rule 4C, describes some limits on accessibility of civil court records in certain proceedings, those being FED actions, small claims, and foreclosure cases. While those cases are pending, no remote access is available, and the records are only accessible by the public at a courthouse. And in those cases, remote access to the records by the public are only available if and after a judgment is entered against a defendant. The fourth part of the rule, Rule 40, simply provides that all other records other than those that are identified for which the records aren't available and for which the rules provides for some limitations on accessibility, all other records are accessible by the public remotely and at a courthouse, unless otherwise provided by law or by court order. The final part of the rule, Rule 4E, describes information that is non-public. So in cases where the records are available to the public, there are still instances of documents or types of information that still will be non-public. And this rule describes what those categories are. And they're things like names of minors, social security numbers, personal financial records, or trade secrets. And there's also a catch-all which provides for any other information or court record that is prohibited by a law. It will also not be accessible to the public. And that's a brief overview of Rule 4 and what it provides for access to court records.
Thank you, Eric. I would also just point out that with respect to Rule 4A1 regarding the timing and access of the records, it talks about 3 days after acceptance of the filing by the clerk. For the start of a case, the purpose of that is to ensure that the public is not aware of the case before at least one defendant has been served and has had the opportunity, if necessary, to act to protect their privacy. Now, with respect to the next element, I'd like to turn to the juror information piece, which is Rule 8. It really tracks the current practices now. Juror information really comes in two different points in time in the life of a juror. One is during juror service. There is and has been in effect a statute, Title 14, Section 1254A, subsections 7 through 9, which talk about access to juror information during that particular period of time, jury service. After jury service, it's covered by another statute, that's Title 14, Section 1254-B, and that is access to the jurors' names following the completion of the entire pool's jury service. During jury service, no public access is allowed to juror information, remotely or at a courthouse or otherwise. There is limited access to juror information available to attorneys of record and their agents and to their parties, and also to unrepresented litigants. And the purpose of this is also limited. It's for cases in which jurors are being selected from the pool in the voir dire examination process. And that can only occur at the courthouse. That information can only be accessed at the courthouse where the voir dire is taking place. The requester, typically the party or the agent, under the rule must provide a written signed certification that the requester of the juror information will comply with all requirements of applicable statutes, most notably Title 14, Section 1254A, and any court rules, and will return any materials at the conclusion of the jury panel's role in the case. Typically, there are two sources of information. One is the confidential jury questionnaire, which is available at and only viewable at the clerk's office. This is filled out by the jurors and then sent in to determine whether they are excludable for certain reasons or not by statute. The other piece of information typically provided to the litigants, the parties or unrepresented, or to their attorneys is a summary jury information sheet. If you've done jury trials, and I assume you all have, you've seen them. It's got the juror's name, juror number, occupation, that very brief summary stuff. It is that particular summary sheet that the unrepresented litigants and the attorneys are allowed to take with them and have throughout the course of the trial for the purposes of the voir dire selection. It is that document that is to be returned at the conclusion of the trial. That has always been the case. There's been a standing order in effect to that for years. Mostly it's been honored in the breach. The Rule 8 adds a little impetus to returning that, in that it's now coupled with the written certification by the receiver of the information that it will be returned. After jury service, everything is guided by Title 14, Section 1254B, which allows public access to juror names. It may be requested only by a motion with an affidavit stating the basis for the request. And the court may grant the motion subject to appropriate conditions to protect juror privacy, and only upon a determination that the disclosure is in the interests of justice. Factors that may be considered by the court include, but are not limited to, encouraging candid responses from jurors in the future, safety and privacy interests of the jurors, and the interests of the media and the public generally in ensuring the trials are conducted ethically and without bias. Separately, there are grand juries, and all information about grand jurors and prospective grand jurors is accessible only by the court or the court clerk. Finally, the last segment that I wanted to tell you about is the BCD and its interrelationship with the RECS rules. Procedures in the BCD are governed by civil rules of procedure 130 through 140. Under those rules, cases in the BCD docket were subject to rules regarding electronic communications by and between the parties and between the parties and the court through the BCD clerk's office. That's Rule 138. There's also subject to rules regarding electronic filing of pleadings and documents. That's Rule 139, and electronic service of notices, pleadings, or documents by the parties in the court, Rule 140. Quite simply, those electronic communications and filings referred to in those rules were emails. The advent of the court's new digital CMS system will eliminate the need for email to accomplish those purposes, and accordingly, minor edits will be made to civil rules 130 through 134 to specifically refer to the main rules of electronic court systems, the CMS system that we'll be implementing. Substantial edits are being made to Rule 138 regarding electronic communications, again, to make it consistent with RECS and with CMS. And Rules 139 and 140 will be eliminated altogether. They won't be necessary because of CMS. However, because pro se parties who are not registered users of the digital CMS system will have to file paper pleadings and documents with the court, they may elect to opt in to email service under the civil rules, but they will not be able to use email for filing. Having covered those specific sections, the agenda calls for a question and answer, and we are aware of at least one question that's been presented, and I'd like to turn that over to Eric, if I may.
Sure. My understanding that there was a question about under Rule 4A2 regarding a situation where a complaint is filed with a motion for ex parte attachment, and whether an order granting that ex parte attachment be accessible by the opposing party after the court ruled on the motion, but before the plaintiff had an opportunity to perfect filing of the attachment. And I think that's a good question, and I initially had a question in my mind about that too. And I think that question also would apply to a situation where someone had also a plaintiff was also seeking a TRO. And I think the answer is no. So Rule 4A1 defines when a record is accessible, and there's, as I mentioned earlier, there's two pieces to that: 3 days after acceptance of the filing, and then after proof of service on at least one defendant has been made. And so you would initiate your action, and when you filed your action, you would have a motion for attachment that would be filed ex parte with that, and you'd be doing that under Rule 3 of the main rules of civil procedure, and you wouldn't yet serve the defendant with the complaint or the motion or the order that you would obtain on the motion. You would do that under Rule 4 once you've done after they've been filed. And so if you filed your motion for attachment, the court would act on that motion, would enter the order, you'd get a copy of the order, you'd make your attachments, and then you'd serve the defendant under Rule 4 of the rules of civil procedure. And after that, you'd file your proof of service. And then at that point, then the records would become accessible to the party and the public, but it would only be occurring after the defendant was receiving a copy of the complaint and the attachments.
Thank you, Eric. At this point, I'd like to turn it over to the next segment on Justice Gorman.
Thank you, Justice Humphreys. Go ahead, Justice Gorman.
I'm happy to start, but are there any other questions for Justice Humphrey before we move on?
Justice Gorman, I think the rest of the questions I've got compiled here, and we'll be doing it at the end just so we kind of stay on track for the panelists, if that's okay.
Okay, great. Good afternoon. Thank you all for being here, although I can't see you. Before I start, I have to thank our brilliant family division representatives, Caroline Ova, Joanna Davis, and Betsy Boardman, for continuing to work tirelessly towards a successful launch. And I want to make sure that you all understand that they, along with my fabulous panelists, Maureen Boston and Erica Bristol, will be available to answer any of your difficult questions. So my topic is Rule 7, which is the rule dealing with family cases. And let me begin by explaining that the cases that involve families and children were the cases that caused most consternation among rule drafters and early reviewers, as we struggled, and I mean struggled, to find a way that provided the courts, the parties, and their lawyers with the benefits of an electronic case system, provided some transparency, and at the same time preserved the need for family and individual privacy. And to top it off, we needed to do this in the context of an enormous number of cases where most of the litigants are likely to be unrepresented. This was no small feat. The system we created is one that we believe walks a fine line between access and privacy by using the built-in distinctions between courthouse access and remote access. Courthouse access refers to electronic access at a public computer terminal located in a courthouse. It does not mean review of a paper file, and it does require that a person who wishes to review a file actually come to a courthouse. Remote access refers to electronic access to a court record from any device, anywhere. Now, you all know the specifics of Rule 7. First, there's no remote access to any family court records except by the parties and their attorneys. Second, in some specified case types, all court records are closed entirely to the public, meaning there is no public access either remotely or at the courthouse. Parties and their attorneys can access these records either in person or remotely, but the public cannot. And these are the case types that you would expect. They are the ones that are currently closed, and we added to the list slightly. So this includes child protection matters, adoptions. We added guardianships of minors, name changes for minors, petitions for court-authorized abortions for minors, emancipation of minors, and any assisted reproduction matters. And then the remaining Family Matters, which comprises most FMs, protection from abuse cases, and protection from harassment cases. All of those cases can be publicly accessed, but only at a courthouse. Now, this limitation on public access is different from the kind of access allowed under the rules for civil and criminal cases, because for those case types, the rules do offer some remote public access. So why did we choose a different approach for family cases? Well, first of all, remember that there are some family cases that are already closed altogether to the public. Think about adoption cases and child protective cases. And then think about the sensitive and personal nature of the information contained in all family cases. In those cases, the court has always had concerns about offering online access. Just think about what's in there. GAL reports, education evaluation of children, parenting evaluations, financial records, and think about how many different documents contain sensitive or personal information. Even the relatively bland complaint for divorce may allow people to see that you had one or more of your children before, as my father used to say, before benefit of marriage. Now, whose business is that really? So think about what's in those records, and then think about how many litigants are self-represented in these case types. Our records show that up to about 85% of family cases have either one or more unrepresented party at any given time. We are practical people, and we recognize that asking unrepresented parties to accurately identify and redact sensitive information from the extensive pleadings would be difficult. Now, initially, as some of you will remember, we tried to strike the right balance between public access and privacy interests by planning to allow public access, remote or at the courthouse, only to summaries of the pleadings and orders. Under this approach, parties and judges would have been required to complete 2 forms for pleadings and court orders: a public summary with generic and non-personal information, and the traditional detailed pleading or order, which would then be deemed non-public. As you might imagine, this approach drew strong objections from the family bar, both because of the extra effort the duplication would cause, but also because it would dramatically limit lawyers' access to these files. I can say that I was personally surprised to learn that some, perhaps many, family lawyers frequently found themselves reviewing files done by other lawyers in order to figure out how to do something. And without intending anything of the sort, we would have ended this aspect of legal education. In addition, although there certainly would have been a method for lawyers or others to seek out court approval for access to more than just the summaries, any process we created would have presented problems in protection from abuse cases. Lawyers representing parties in those cases want and need nearly immediate access to other cases involving the parties, whether those cases are criminal cases, other PFA cases, or any associated family cases. Because PFA cases often involve ex parte orders that affect constitutional rights, an access process that required a filing, notice, and then hearing of that motion before the PFA complaint could be heard would have been inefficient and problematic. And while we're talking about PFAs, remember the special publication challenge they present under the Violence Against Women Act. VAWA at 18 USC section 2265 D3 reads, "The state, Indian tribe, or territory shall not make available publicly on the internet any information regarding the registration, filing of a petition for, or issuance of a protection order, restraining order, or injunction in either the issuing or enforcing state, tribal, or territorial jurisdiction, if such publication would be likely to publicly reveal the identity or location of the party protected under such order." Now, as you can see, this broad language implicates more than simply a victim's name and/or address. And although it might permit some redacted documents and information to be provided on the internet, given the number of unrepresented parties involved in PFAs, the speed with which the cases have to be processed, and the virtual guarantee that there would be problems with requiring redacted or summarized pleadings, we were very concerned that allowing any remote access to PFAs or to PFHs involving domestic or sexual violence would run afoul of the spirit, if not the letter, of VAWA. And as a side note, VAWA's language does not limit any information to only the PFA order itself or to that case. There is at least an argument to be made that the prohibition should be extended to other case types that may contain information that could potentially identify a person protected by a PFA. And that brings us back to family matters. So, based on the feedback that we received with regard to the idea of allowing access only to summaries in any family cases, and because we had decided that we would have to prohibit any remote access for PFAs and PFHs, regardless of how other family cases were handled, the SJC decided to balance the competing demands for access and privacy by adopting the approach reflected in RECS Rule 7. As I said, this approach eliminates all remote access to the public, by the public, to family case records. By requiring members of the public to go to the courthouse to view the files, this approach maintains the current level of access, and it relies in part on practical obscurity to protect privacy interests. In addition, unlike the rules governing civil, criminal, and even juvenile records, Rule 7 designates entire documents and not simply information as non-public. Again, why this different approach? Again, we're back to the recognition that many, if not most of the litigants in these cases will be unrepresented. Relying on them to accurately redact sensitive information from the extensive pleadings or other filings would be difficult at best and impossible in some cases. Furthermore, the form pleadings that we use in family cases involve several questions that call for narrative responses. And even if and when we have access to good automated redaction software, those responses will be more difficult to accurately redact. For that reason, REC 7, Rule 7, designates as non-public those entire documents that contain a lot of sensitive information. And it relies on practical obscurity to protect less sensitive information in the public forums. In keeping with this policy, there are certain documents that the public cannot access even at the courthouse in these cases. They're listed in Rule 7D, and they include documents that are already confidential pursuant to statute, administrative order, or rule, or those that contain particularly sensitive information, like Social Security numbers. Now, it's a little beyond Rule 7, but I can't end without pointing you to Rule 33, which talks about the use of the electronic filing system. The rule establishes who is required to use the electronic filing system and who may use it. And among those who must are self-represented litigants filing or intending to file more than 6 cases that are filed and are not emergency cases in the current calendar year. For purposes of this subdivision, emergency cases are protection from abuse or harassment requests, mental health requests, requests for emergency guardianship of a minor, and 3-party child protection petitions. So if you're filing more than 6 non-emergency cases in a year, the rules have labeled you a little more litigious than most, and you must learn how to and then use the EFS. Thank you very much for the presentation. Erica and Maureen and I are available for any questions that you might have on Rule 7. Chris, I don't know if there were any.
Justice Corbin, I did have one question that came in. I think it would be a good time to answer this one. We have just enough time to do this. The question is, parties and their counsel are excluded from the definition of public, so they have access to information in their cases. Less clear is whether parties and their counsel have access to non-public information in their cases. Please clarify.
So if it's non-public information, they have access to everything that's in their own files.
Okay.
If there's a particular document that a party or lawyer wishes to file and shield from the other party, just like in regular rules now, you'd have to file something with the court to have that shielded from the other litigant or the other attorney in the case.
Thank you. And just for all the attendees, if there's a question that's asked and I didn't ask it the way you were posing it, please feel free to send me another comment, and I can certainly try to follow up. So with that, we'll move on to Judge French from the District Court. Judge French?
Thank you. Good afternoon. I appreciate being invited to participate today. I'd like to talk for a few minutes about filing and also about rules 31 through 35, as well as rule 38. The technical requirements and the way that one actually files is not something I'll be touching on. I will let you know that my understanding and knowledge of the filing process goes something like this: that a PDF file is created, is saved on a hard drive. The user logs into the account with eFile main, locates the case they want to file with. They open a new filing, they attach the documents, and they choose file. And it's about as in-depth as I'm able to go as far as explaining the nuts and bolts as far as the actual filing online. I will note, and I think it's already been mentioned, that there will be a number of trainings with these technical requirements and the how-to nuts and bolts for filing in the future. I think the next one's actually October 8th. That information's online at the Judicial Branch website, and I'm sure we'll be providing that information as well. When we talk about filing, at the moment we're talking about in those regions and courts where e-filing will go live, and the intent was to be going forward in Bangor next week. And at that time, as already been suggested, we were talking about BCD cases, family matters, child protection, small claims, FEDs, foreclosures, and other civil matters. And we're excluding criminal, juvenile, and protection from abuse and harassment cases. So I'll be talking about those cases. And what is obvious, I think, from what I said, is that other courts go live and other jurisdictions go live. Other case types will go live as well. And filers will be required to comply with the rules that I've discussed. Justice Gorman briefly touched on the fact that there are certain required filers or folks that are required to file electronically. And those that are required to file electronically are those that are represented by an attorney, those on behalf of a state government, municipality, or local government, and those that are unrepresented that file 6 or more filings per calendar year. But the good news is everyone else can file if they want to electronically. They have the right to opt in to do so. And if they choose to do that, then they will therefore and thereafter be required to comply with the rules. If someone's represented and they also want to have access through e-filing, they also can opt in, although there's a caveat to that, which is that if they opt in, parties that are currently represented, their email will become essentially open to those that have access to those files that are open either to the public or to the other parties involved in the case. So there's just knowledge about that. I want to make sure that you understand that. So once a filing has been made, that filing becomes effective upon the date that it was filed after it has been accepted by the clerk. So let me explain that a little further. What will be happening is that the filer will be filing, and they can file at any time, any day. Once that's accepted, the filing date or the date of filing will be retroactive back to the time it was filed with the following caveats. And those caveats are that if something is filed Monday through Friday, then the filing date will be prior to 11:59 on the date filed. So something filed at 11:58 Friday, the filing date would be Friday. If something is filed on a weekend after 11:59 on Friday, but prior to the next business date, the filing date will be the next business date. So for example, if something was filed on the Friday before the October 12th holiday weekend, just want to make sure I check my dates. So actually, let me go back. October 12th is the holiday itself. So if something is filed on October 9th of this year, prior to 11:59, then the filing date would be Friday, October 9th. If it was filed October 10th, which is a Saturday, then the filing date would be October 13th, which is the Tuesday, which is the first business day following the weekend and the holiday. It's possible that a filing can be rejected, and it can be rejected for some reasons. For example, if it didn't have the appropriate paperwork, it was a duplicate filing, or there was something else wrong with it, it could be rejected by a clerk. If it's rejected by a clerk and it's resubmitted with a corrected version of the rejected document, the filing date will automatically relate back to the original filing date, provided that a few requirements are met. The first is that it's the first resubmission. The second is that it's resubmitted within 4 business days after the date of the rejection notice. Another thing that's important to note with regard to filing is that electronic signatures are allowed, and there's 3 different ways that electronic signatures can be filed. And those electronic signatures can be a facsimile of a signature. It can be an acknowledgement that it's electronic signature by doing a /s. And there's one more way, and I apologize, I have lost that in my notes, but I'll come back to that in just a few minutes. When filing an electronic document through the e-filing system, it must be a PDF. And the preference is that it be a converted PDF rather than a scanned PDF. Another requirement is that it not be greater than 50 megabytes. Each document must be submitted separately. Additionally, if there have been consolidated matters or consolidated cases for hearing, and there's more than one docket number which applies to the cases that have been consolidated, a separate document needs to be filed with regard to each one of those cases. So if something has been consolidated for hearing, for example, a guardianship and a family matter, and the motion to continue was filed, there must be a separate document with a separate docket number in each of those matters. In some cases, electronic filing is not allowed, and this was mentioned previously as well. And in those cases, there will be a conventional filing, meaning that it's filed in paper with the court. And some of the reasons that they wouldn't be allowed to be filed electronically are, as Justice Gorman suggested, because of VAWA, federal law, or for example, documents which must be inspected in camera by a court before being accessible to parties. In that case, there had to be a notice, a filing, that a conventional filing was made. Justice Mullen will be talking about service of documents, but I want to go back to one of the things that I had talked about previously, which was electronic signatures, and that's Rule 37. I mentioned the two of the 3 possibilities, which is a facsimile signature, and the other is the /s or typographical signature. Another signature would be a scanned signature, which is a situation where someone actually scans the document, and that document is then scanned into the record. The final thing that I wish to discuss with regard to e-filing is non-public court filings. So I want to be very clear that the rules require, and this is Rule 38, that the parties are the ones that are responsible for omitting or redacting non-public information. Court forms which are required to be used if they exist have been generally sorted into public and non-public. However, each of the filers needs to look at those forms before they're filed to decide whether or not there needs to be redacted or whether they need to be identified as non-public, notwithstanding the sorting. For an example, if there's an answer in a complaint or an answer to a motion, which in many cases wouldn't normally be non-public, if information which is confidential or is otherwise not appropriate for release is contained in that file, it must be redacted or indicated as non-public. And the burden, again, is solely on the filers to do this. If in fact someone is filing a document which contains non-public information or redacted information which would otherwise be available, for example, a notice to continue, they need to file a redacted copy as well as a non-redacted copy. And in the comment section of the filing, they would indicate on the non-redacted copy that it's non-public. And that would be an indication that it wouldn't be available to the public. That's all that I had at this time for the general overview of filing. Justice Mullen will talk about service. If there are any questions about anything I said or other questions about filing, I'm happy to address them at this time or have one of my colleagues do so.
Thank you, Judge French. I have a number of questions, but I'm still kind of gathering those are coming in. So why don't we move on to the next section, and then we'll ask all the questions at the end.
I think I'm up then.
I believe so.
I just want to echo my colleagues' comments about, thanking you for the invitation. As probably most of you know, the main rules of electronic court systems is being referred to more and more by the acronym RECS. After in the past, these rules have been known also as DECRA, which stood for Digital Electronic Court Records Act, and also the main rules of electronic court records access. And my hope is that the acronyms have ended for now anyway. So for example, we don't come up with yet another acronym for billing to accounts, which might precede RECS, and I came up with customer account report. But if we use that, I mean, I would submit we don't need an acronym of CAREX, in my opinion, for these rules. So with that lame attempt at humor, I've got 5 rules to discuss in about 15 minutes, so I'm going to try to get through them quickly. Rule 10 deals with cases or court records that are not accessible by the public. The rule is entitled Sealing or Impounding Public Records or Public Cases or Court Records. And there may be some confusion or uncertainty as to the difference between Rule 10 and Rule 11, which is the rule for obtaining access to sealed or impounded cases or court records, and to certain non-public cases or court records. So either I'll hopefully make things either less confusing or more confusing after this presentation. First of all, I want to emphasize that the new rules are not imposing a slew of new restrictions on case information. I mean, as a general rule, public FM cases can only be viewed at the courthouse. Look at Rule 7. Certain civil cases, such as FEDs, are not public until a judgment is entered. Most adult criminal cases are still going to be public, and most juvenile cases, are going to be continued to be private. So I hope people don't get too riled up about, a new slew of cases, rules, a new slew of restrictions. I don't think that's going to turn out to be the case. Rule 10 provides a mechanism for a party, person, or entity that has standing to file a motion to impound or to seal what would otherwise be a public case or a court record in a case. Any motion to impound or seal has to be accompanied by an affidavit stating the basis for the standing that the person has to make the motion and the reason for the request to seal. including a statement describing the harm that the filer alleges will occur should the motion to seal or impound not be granted. The motion and any attachments should be labeled, quote, non-public when filed. And a person who is filing such a motion has to serve it to seal or impound on all parties unless the motion is made ex parte. Ex parte motions to seal or impound are allowed, and in all cases, the motion, related documents, and affidavits are not public and are not posted on the Registry of Actions, which we know now used to be known as the docket, until the ruling is made. And the court can, but doesn't have to, conduct a hearing on the request. What's the test or standard review for deciding whether or not to grant the motion by the judge? Well, the judge, when presented with such a motion, should be weighing whether the reasonable expectation of privacy of a litigant, according to the rule, substantially outweighs the public interest in public access to the case or court record, after considering the following factors: an individual's personal safety, health, or well-being, an individual's substantial personal, business, or reputational interest versus the public's interest in access to information in the court record. If the motion's granted, then all records in that case and any records subsequently filed are not to be accessible to the public. Thereafter, if the motion is granted, thereafter, you should make sure that any documents filed in the case under seal or impoundment are clearly marked, quote, non-public. If you don't, the document can be sent back to you. I'm assuming in extreme cases, sanctions can be imposed, so just don't, open yourself up to those types of unpleasantries, and just to make sure you label the document the way it should be labeled. Rule 11 provides a mechanism for obtaining access to sealed or impounded records and to certain non-public cases or court records. It also provides a mechanism to access records made non-public by a law that also authorizes the court to authorize access in special circumstances or specific circumstances. And the one that comes to my mind anyway is what we used to call Clifford orders. 11 applies to
To me, or we lost Justice Mullen?
We appear to have lost Justice Mullen, so
Okay.
let's take a second, see if he's able to rejoin. Amy, if you're online, can you please place a call into his office and see if he's aware?
It's always that awkward moment where I don't know if it's me or if it's the presenter. While we are attempting to get Justice Mullen back on the phone, or I'm sorry, back on the call, why don't we go ahead and just give him another 30 seconds or so and see if he can rejoin us, and then we'll ask some questions to the panel. Then we can come back with Justice Mullen. I did have one question for Justice Mullen, if someone else would like to take a stab at it. Do the motions to impound have to comport with Maine Rule of Civil Procedure number 4? Does anyone else want to take that, or shall we wait for Justice Mullen?
I think it probably speaks to what the Chief Justice started with, and that the Maine Rules of Civil Procedure are still in effect. I think I'm a little confused by the question because I don't have the civil rules in front of me, but I think Rule 4 is about service of a summons in the summons rules. And so, but I do think the civil rules continue to apply is the answer to that question. So to the extent that Rule 4 addresses service of motions, or whatever the civil rule is that does address service of motions, that's the one that folks need to follow in filing and serving.
Thank you, Maureen. With that, I see that Justice Mullen has returned. Justice Mullen, are you able to hear us?
Yes, it was so compelling. I guess I got heated up the wires, and I got shut off, but I'm back. Yes.
Well, everyone here froze because we didn't know whether it was us or you. So you're back now, and we're very happy that you're back. So please continue.
Okay. So anyone can file a motion for access. And I think I already said this, but I'll repeat myself. A non-party who files a motion for access can be considered a party in interest for the limited purpose of the motion. One might ask why. So what happens if the address of someone who's entitled to be heard has a confidential address? In cases that are not criminal, the caption has to state prominently confidential party, court service requested, or confidential affected non-party, court service requested. Now, you should note that the court can waive that requirement on motion or on its own initiative if it finds that good faith efforts have been made or good faith efforts have been made and they aren't likely to be successful or could endanger the person to be served. And I know we're not supposed to talk about criminal cases, but in criminal cases, the responsibility for a service on an alleged victim or witness is on the state who will be served, and then they are supposed to send or forward the notice of motion to the alleged victim or witness. Who gets to be heard? Well, the parties, the movement, and the quote affected persons, end of quote. It can be, you can be heard by written submissions, or if the court decides, they can have a hearing. If the records were previously sealed, a resulting motion for access can be granted only if the court finds that the previous order must be amended because the rule says the court finds the need for public access outweighs substantially a party's reasonable expectations of privacy. And for non-public records, access can be granted only if the court finds the motion contains explicit legal authority for public or limited non-party access to those cases or court records. And if no such legal authority is listed, then the motion should be granted only upon a showing of, according to the rule, extraordinary circumstances to require access. What types of civil records are not generally open to the public? Mental health commitment proceedings, med-mal panel proceedings come to mind, sterilization proceedings, proceedings for extreme weapon protection orders. And if you don't know what I'm talking about, that's a new law that people should probably look at. Minor settlement proceedings and HIV or AIDS testing proceedings. There's also certain limitations on accessibility of records in FED, small claims, and foreclosure cases. Insofar as before judgment, these records are only supposed to be reviewable or available for review at the courthouse. Okay, so Rule 31 is entitled General Conditions for Filing and Service, and there's a certain overlap between Chief Judge French's and my presentations, and so to the extent I repeat what he said, I apologize, but I have my outline and I'm going to stick to it. First of all, what's very important is you need to make sure that you use the forms where an applicable form exists. And if you don't, you can get into trouble. So use the forms that have been created for this purpose. Attorneys will register for access to the electronic filing system and comply with the registration conditions. Obviously, one important condition is to maintain one or more working email addresses to accept email notification and service from the electronic filing system. I'm just going to refer to it as EFS. To have access to the EFS, one has to register for access, comply with the registration conditions when using the EFS. As I said, maintain one or more working addresses at which you agree to accept email notification and service from the EFS. How service is effectuated depends upon who's serving. Registered users will serve electronically, subject to some exceptions, while non-registered users have to serve conventionally, as I understand it, in all cases. So just because you're a registered user, don't automatically expect that you're going to receive all service through the electronic filing system, especially if someone's trying to serve you and they're a non-registered user. Anything filed through the EFS or e-filing has to be served through the EFS, except case initiating documents such as the complaint, summonses, subpoenas, documents that are incapable of being e-filed. When who you need to serve is not a registered user, and also if there's a court order that requires conventional service. So that takes care of 35 anyway, 31. Rule 35, that's the time of filing service and response. Filing date begins at 12 a.m. and ends at 11:59 p.m. in the time zone in which the court is located. I think as Judge French already pointed out, the filing Monday through Friday, the filing date is the day it's submitted. Saturday, Sunday, or a holiday, it's the next business day. For any questions about timeliness, the time and date registered by the electronic filing system will determine. The filing date is determinative in computing deadlines, even if the clerk accepts a document on a different date. Following submission, the clerk will either accept or reject the electronic document. This is the review by the clerk is just ministerial. And by that I mean she's just checking for signatures, bar numbers, required fees, or if there's no fee or waiver request, she's not going to be looking at the merits of anything. Acceptance equals the document that has been filed. An acceptance notice is sent out to the parties. If it's rejected, that means it's not been filed or is considered not to have been filed. The rejection notice should be sent to the filing party, who is then obliged to send notice of the rejection to the opposing parties. The rejection notice is supposed to identify the basis for the rejection. The rejected submission will not be entered on what we formally call the docket, the registry of actions. So what happens if you want to resubmit a rejected document? Well, first you must include in the comments to the court field the following, along with the resubmitted document, the words, quote, resubmission of filing, original submission unsuccessful, end of quote, the date of your original submission, the date of the rejection notice, and then a statement confirming that this is the first resubmission. Resubmitted documents that are accepted eventually by the clerk will be considered filed as of the date of the original submission. If it was in fact the first resubmission, and it's submitted within 4 business days after the date of the rejection notice. And you should note that if the notice of rejection is provided by mail, then the filer has 7 days to resubmit instead of 4. Resubmissions that are late or are submitted more than once are supposed to be allowed only to relate back to the original date filed, are only allowed to relate back to the original file date upon court approval. The response time is increased by 4 business days if the file date relates back to the date of the original submission. And then Rule 36, all documents filed in the EFS, this is talking about service of electronic documents, all documents filed in the electronic filing system must be served through the electronic filing system, except the following that have to be served through conventional means: summonses, complaints, indictments, other case initiating documents, as I said, subpoenas, documents that can't be filed electronically, documents that are served on those who aren't registered users, and any document that the court has required conventional service on. There's currently no service contact address that can be masked from view, as I understand. And in fact, it can be searched by anyone in the system. Anybody has the ability to make changes to others' email addresses in their service contact listing. That may be changed, but that's, at least at present, that's what I understand the situation to be. If you use the EFS system, I think I've already indicated that you are deemed consented to be served by the EFS. Let's see. Regardless of the method of filing, sealed, impounded, and non-public documents and documents submitted for in-camera review are not to be served on service contacts or conventional service recipients. And when a filer submits a document that must be served electronically, you must complete service on any required service contacts at the time of filing, and that's in Rule 36D. So in essence, you must select file and serve for any document required to be served electronically. You'd select file only for ex parte motions and file documents that are sealed, impounded, or submitted for an in-camera review, and you'd select serve only for documents that are not filed in EFS, but are only served through the system like Discovery. And so that is admittedly kind of a whirlwind tour through those rules, and I'll turn it back to you, Chris.
Thank you very much, Your Honor. At this point, we're going to ask some questions to the panel, and I've been trying furiously to gather them up, the questions that come in, and organize them, but I apologize to the panel ahead of time if I'm a little bit out of order, we jump around a little bit. So we're going to start off with some general questions and then get into some more specifics. And again, if you have questions, you can still ask them in the Q&A box at the bottom of your screen. First general question. This is kind of a little more esoteric. If you could point to just a couple things how the RECS system will differ from the federal PACER e-filing system, what would those things be?
I can take that question. I have not personally used PACER before, but from a high level, e-file main will be only for filing documents, or submitting filings into a case and not accessing documents as you can in PACER, whereas we'll be using things like Portal and Research, which are other products that main will have available at some point to actually access court documents.
Thank you. And if any of the other panelists want to jump in there, seeing none, move on to the next question. What are the plans for public access computers being installed in courthouses?
I can take that one, Chris. So with regard to the plans, we are actually implementing the public access computers at each of the courthouses in time-wise when the court regions go live. So I'm not so we are setting those up. And just I don't know if there's any deeper questions or thoughts surrounding that.
Well, just a follow-up question then. What are the plans for computer access during COVID?
So,
public access.
Yeah, so very good question. We are actually, in accordance with the Maine CDC guidelines concerning electronic device use, we will be having available latex gloves, alcohol wipes, hand sanitizer, and we will also be working to draft procedures and instructions that will be posted as signage in the areas for the public access computers.
Thank you. Will the public access computers at the courthouse support both e-filing and search? One or both?
Both. So the computers are really being installed for a couple of different purposes. I mean, so first of all, you'll be able to access cases through the Odyssey portal on the computers, as well as through research when that becomes available. Other services available are things like guide and file interviews. So guide and file interviews are a lot like the TurboTax experience, where if I'm a filer, I can go to a website, I can say, and the computer will say, well, what interview do you want to do today? And I'll say, well, I want to file a small claims case, or I want to file for divorce. And so these interviews are designed, they're interactive, to ask you questions necessary to collect the information, to compile the forms that are needed, and then to submit those to the court. So electronically. So we've got a couple of different interviews that will be available for when we go live. Also regarding e-filing on the e-file side, e-file main will be available for folks to log into their accounts to look at filings. But initially, as of right now, we do not have it set up so that it can be used for new filings. You know, one of the things is that, you know, we're implementing these for the first time. You know, we've looked at these types of computers that are installed in other states across the country, and we're going to look at the volume, at the intended use, and really look to make changes here as we move forward.
Thanks, Chris. One more question. It's a bit of a follow-up. Will the RECS with the confidentiality protections contained therein apply to both e-filing and research?
Not sure I understand the question correctly, but I think the answer would be yes. I mean, you've got part one of the RECS, which we've talked about today, covers accessibility, and then part two covers the e-filing requirements and guidelines.
All right. Another question regarding courthouse inspection. How will the courthouse inspection rules be encouraged and or enforced?
Okay. So, so we are setting up, you know, in addition to setting up the public access computers, which will allow a level of access to the Odyssey portal so that you'll be able to get access to the cases identified as courthouse inspection only, as well as the related documents. You know, we are setting up signage as well to instruct users that come into the courthouse on how to use them. This would be in addition to the COVID signage that we had just talked about. The other piece is we are also going to be training clerks on providing support to users that are actually using the computers, which we've also have set up so that court clerks will be able to provide that level of support directly from the safety and security of the clerk's office.
Question came in, approximately how many pages does 50 megabytes relate to? That's an awful lot of pages. I think it probably depends upon the attachments, you know, that are included with it, including photographs. But Will or Chris, do you want to speak to that?
Sure. In short, it is a lot of pages. Depending on the resolution of the pages that they attach, we recommend 300 dpi as the resolution setting. And in the past, we've been able to attach documents as large as 2,000–3,000 pages to a 35 megabyte site. And so with 50, it should be upwards of, you know, 3,000–4,000 pages.
Please don't file that many.
Fair enough, Your Honor. Is a converted PDF one where the search is text, perhaps, where the text is searchable? I believe that if you're converting it from a Word document, if you're saving it down as a PDF, I believe the text is searchable there. Is that correct?
Yes, it is.
If you're scanning a document in from a scanner as a PDF, is the text searchable in that case?
Typically not, unless they send it through something that converts it back to a text searchable PDF.
So that would be something you need to draft the document, then save it down as a PDF versus printing it and scanning it, correct?
Yes, and Chris Ober, you can chime in as well if you want.
Yes, I was just getting ready to. So one of the nice features that we have set up with our system is called this optical character recognition or OCR functionality, so that any PDF that is submitted through eFile main, when upon submission, it's going to be converted to a searchable, text readable PDF document, regardless of the PDF type of PDF file that you're submitting, whether it be just a scanned image or if it's an actual document. So,
Just to follow up on that, Chris, in my experience, anytime you can save a Word document down as a PDF versus relying upon OCR technology, it's always a better to actually save it down as a PDF. So,
agreed.
allow a much smoother search. Another question: if you have two email addresses, such as yourself and a legal assistant, does one have to be filed? Does one have to file in both emails?
Will, I'll let you answer that one.
Yeah, I guess I'm just trying to understand the question. So you can include a like a kind of a CC copy along with your filing so that other staff are aware of the filing submission. So that is an option available. I'm not sure if that answered the question or not.
I'm not entirely sure, Will. I think the issue is really that, say, the attorney's filing something and leaving on vacation to the Himalayas, won't have any access, and they put their legal assistant email on there. Do you have to? Can you just attach another email and have that person be in the loop
To be able to resubmit if it's rejected? Is that the implication?
or at least get notice? Yes.
Yes, so they would get notice. I'm not sure if they can make a resubmission. I can follow up on that.
Okay. Let's see. Another question. This one may have been answered. If filing a non-public document, like a child support affidavit, I know we're not, and do you file one non-redacted and indicate it's non-public, or would non-public forms have to be redacted? I believe it may have been answered, but.
I'm going to ask Caroline to answer this one.
Carolyn?
I can take that. The answer is no. If the document itself is designated as a non-public document, you don't have to submit a redacted public version, and the rule that controls that is Rule 38. I'm sorry, just to clarify again, that requirement on redaction is only if the otherwise public document contains non-public information.
And just to clarify, who is responsible for redacting that non-public information from filings? The filer or the court?
Take that as well, and it's the filer, and that's in Rule 38, subsection A.
And just following up on that, another question. Find it. Sorry, I'll get to it in 1 second. If you can see the entire record, can you download filings from the other parties? Chris or Will?
So I'm not sure I fully understand the context of that question, but I will tell you that if a court record is sealed, then it's not available online, either searchable or accessible.
Okay. And just to follow up on the previous question, about multiple emails, firms can set up an administrative account. I believe that may eliminate some of those issues with concerns with an attorney filing something and then leaving. So that can be I think that was the response there. Another question, will one see its own firm's filings when logged in, or is there a way to see the entire docket record for cases in which one's firm is representing a party? That may be a little bit nuts and bolts, but.
Yes, so in their filing history, they'll only see what they had personally filed. but there is an option to filter, or I guess expand the filter and show what your firm has filed as well.
Okay. Here we go. If we'd be able to see documents that are not public, or what will it show if documents are not public? Is there at least an entry that says there's something filed there that is not public?
Caroline, you want to take this one again?
I mean, I think that pertains a little bit to the nuts and bolts, but my understanding, and Chris and Will, feel free to jump in here, is the registry of actions, which what we now call the docket record, will indicate the full docket for that case and will state if something that is non-public was filed, but you will not be able to view the document itself.
So let me just expand on that a little, because this will happen with some frequency in family cases. If someone actually goes to a courthouse and wants to look at a divorce file, an FM file, the member of the public will be able to use the kiosk to look at the registry of actions. And one of the entries there will say child support order filed. If you click on that, nothing will open because that is a non-public document. So the fact that one was filed will be public, but you will not be able to have access to it. I don't know if that answers the question or not, but there seem to be a lot of nuts and bolts questions here today. Maureen, did you want to weigh in?
Oh, no, sorry, I'll say.
Okay.
And to Justice Gorman's point, I do want to, I think Chief Judge French mentioned this, but there are separate trainings focused on the nuts and bolts where a lot of demos are provided. So I think for the folks who really want to have kind of a visual demonstration of what this will look like and how you will do it, I really encourage you to sign up for one of those. They're posted on the MJB website. If you go to the home page on the left side, there's a tab called eCourts. And all the times are provided there. But certainly for questions about the rules themselves, we're more than happy to provide that information here.
Thank you. And just as a reminder, the MTLA will be sponsoring some of those presentations as well, so stay tuned to this channel. Another question?
Well, I just want to make sure Catherine Wiltuck's on the call, and to the extent some entries, Catherine, do you want to add to that? I just want to make sure I'm not providing oversimplistic information and responding to that question about what will be visible with respect to non-public information on the registry of actions.
So it was my understanding, but again, I'm going to look to Chris to confirm that there are some entries in the ROA that actually would not be visible to the public, that will only be visible to clerks who are entering them.
That is correct. That is correct. So you know, when we look at the layers of security, you've got the cases that are accessible online or not. And within those cases, are the documents publicly available or not? But then also, you know, this third element of the registry of actions, the case events, if there are case events that are deemed to be non-public, then yes, those will also be hidden and only viewable to internal to the court clerks.
Thank you. Another couple questions here, and these are in no particular order. Rule 33F indicates that misuse of the EFS might subject the user to criminal prosecution. Are there any plans to define criminal sanctions in the criminal statutes? That's a big question.
I would say that there's been no discussion of that topic yet.
Very well, thank you, Your Honor. Another question, should Rule 4B include involuntary medication cases from the Maine state prison? Or I guess I should say, why are those not part of that, Rule 4B, if anyone wants to.
I think that's a good question. And I think that refers to Title 34A, Section 3049, the involuntary medication of individuals who reside in the mental health unit of a prison. It's not for me to make a decision on that today, but I think that's something that the RECS team ought to consider. I think it's a very good question.
you. Additional question. Rule 4E2A states that residence addresses are non-public information. The current civil action summary sheets request address information for all parties. Will the summary sheet be inaccessible to the public, or must the parties' addresses no longer be included on the summary sheet or be redacted?
Is Laura Perlman on? I'm not sure what the status of the, hi Laura, can you respond to the form development? You're muted.
I just had trouble with my mouse. I'm sorry.
It's okay.
Yes, the civil, I think all of the summary sheets, well, I won't speak to civil, it's going to be a non-public document. Will not be shared. So the information will still be provided with when it's filed, but those are going to be non-public.
Thank you, Laura. Rule 37D, as in dog, appears to require registered users, attorneys included, to sign the document by facsimile or typographical signature. Therefore, it appears that a scanned signature is not acceptable for documents filed by registered users. Is that a correct reading of that rule? Allison?
I actually was chatting with Catherine Wiltuck about this one, and while that question was posed, and Catherine, I thought you had some great guidance on this one.
So I think that a scanned signature should have been included, but it was not. I think the important part of that section, though, is that the username and password are going to be effectively your signature. So that is the signature that will be recognized by the system.
Thank you, Catherine. Do rules 10 and 11 govern civil cases where the parties seek a confidentiality order to make sure that certain information as designated by the parties is not made public? You may have already addressed that question.
I can take that.
Thank you.
I think the, I think what they're trying to get at is when the parties agree, as opposed to needing a motion to get something sealed or impounded, that the parties actually agree that it should be non-public. I don't think there is any barrier to that, but I don't think the rules address it specifically.
Okay. And now we've had a number of questions come in since we started the question answer period, so these will really not be in any certain order. Have filing fees been determined yet? Will fees be based on each document filed?
I can take that, Chris. So with regard to filing fees, and this is a bit of a recap of what we talked about in the past presentations, is that there's no cost to e-filing. The filing fees are the filing fees that are in place today, according to the schedule and the rules. The only additional fee that could be imposed with electronic filing is if you use a credit card. There is a fee of 2.89% per the total transaction amount that is assessed on top of that, and that is purely to cover the fees that are associated with the pay card merchant. So these are the fees that Visa, Discover, American Express, those are the fees that they charge for the use of the card. But other than that, there's no other fees. I should also mention that you will also have the ability of using payment options to pay filing fees as an electronic check, at which point there is only a 25-cent fee to use that payment method.
Thank you. And just for everyone's edification, that topic was covered in quite a bit of detail on the previous presentation done a couple weeks ago, which is available on our website as well as the judicial branch website.
Chris, I just want to, I think Chris Silver may have already mentioned that, but we are talking about filing fees for initial filings. For example, if you file a motion to continue, there isn't going to be a separate fee for that. And that may have already been covered on the prior presentation, but I did think that was worth nuancing.
Okay. Is PFA e-filing still on hold until spring?
Yes.
Just going through some of the questions now. What is the preferred or best practice for when parties dispute whether information in a file document should be non-public or public under RECS 37 and 38? Anyone like to address that question?
I guess as an attorney in my practice, I think that it will be on the filing party to make the decision about whether or not to redact the information. And if the other party disagrees, then you can follow the rules in terms of asking the court to correct it.
Chris, I don't know if this is directly responsive to the question or not, but I'm looking at Rule 38 D3, which says, upon motion, the court may consider any matter relating to submissions designated as non-public in the EFS. That suggests a motion practice to resolve that issue, but that may not be correct.
That sounds like the answer, Your Honor. Let's see. This is a question I believe we answered the previous session, but I'm sure other folks have it. When a region goes live, will the case availability be on a prospective-only basis? Cases filed after the effective date, or will previously filed cases be available? Does it matter if cases are still pending?
Chris, can you explain how Chris Oberg, I'm sorry, can you explain how that process is being worked out in the Bangor region, please?
Yes, certainly. So all of the data, all of the case data that we have in our current system, MEGIS, is going through a conversion process where we're bringing it over into the new system. And this would be for both completed cases as well as those that were pending. So we're bringing over everything. And so when we turn on a region, or in this case, when we turn on Bangor and the BCD, when that date is set, it'll be those case types for those locations that are going live. All that data will be in there. All that data will be available. All of that data will be aligned with accessibility, will align with RECS. I can also tell you that we have launched a massive campaign to scan all of the pending documents, all of the documents that are associated with the pending case files, so that when we flip the switch on day one, we will have those documents up and running and in part of the system as we move forward. Obviously, cases that become reactivated, closed cases that become reactivated as we move forward, will also be scanned, the documents, and brought into the system as well. And so I think that pretty much covers it.
Thank you, Chris. There's a table of contents be included at some point with the RECS rules posted online. So your plans for a table of contents?
I think that's a great idea.
So I think we'll put that under the to be discussed at a later date, and that's a good idea. Let's see. Rule 4E2A states that residence addresses are non-public. In actions like residential FEDs, the tenant's address is an element of the action and usually included in the complaint. Since addresses are non-public, would an FED complaint be filed under seal?
I can take that.
Thank you, Laura.
FEDs are not available for inspection except at the courthouse until judgment enters against the defendant. And maybe that doesn't answer the whole question, but they're not going to be remotely accessible.
Well, and Laura, just to kind of jump in with you on this one, the complaint, you would have to redact the information within the complaint. So this is the rule referenced earlier, I believe, by Chief Judge French, where the burden really is on the party, I believe it's Rule 38, to redact the information contained within the otherwise public document and designate it accordingly. And Laura's additional point on like the level of access is absolutely on point.
And one of the things, let me just jump in a little bit on that. So in the family cases, there's been a giant movement towards creating forms for virtually everything that occurs, because there are so many unrepresented litigants involved in these cases. To the extent anyone listening or watching believes that there are forms that should be created for other case types, if they would reach out to Catherine Wiltuck and let her know, we can contemplate working on those too. It occurs to me, based on this question, that maybe a form FED complaint would be useful, so that there's no real reason to redact. There's a separate document that contains the residential address on it.
Thank you, Your Honor. And there is also, sorry, go ahead.
Yeah, sorry, just a couple of quick things to add on there. Related things that I think are important to convey. You know, as part of this, you know, we are soon working to publish a new version of court forms that, you know, we reviewed all of the court forms that we've had in relation to the RECS rules to identify which forms that we have non-public data in accordance with RECS. And for those forms that are identified, we've added or will be adding a header on top that says contains non-public information. So what we're trying to do there is really take a lot of the guesswork out. Is this form non-public or public according to the rules? We're really trying to take that guesswork out. The other related piece that's important, and you may have heard this in past presentations, is that you know, we have partnered with Tyler Technologies to implement their robust redaction software engine as part of eFile main, so that when I'm an attorney, I log in, I go to electronically file, the system will automatically comb through my documents and do a redaction review and suggest back things that I might want to look at and change. And so it's a rather robust algorithm that looks for things like dates of birth and social security numbers and things of that nature. And so we are trying very hard to tie that very close to when the BCD and Bangor go live, but that should be a new feature service that's coming online very soon.
Thank you, Chris. And just so to everyone knows, I just sent out the eCourts Help email address to all attendees in the chat function. If there are other questions, or if the questions weren't answered today, the address is available to submit additional questions about these rules and these processes. So that should be in your chat. If you can't see that, please let the MTLA know or the court know, and I'm sure it's available on both of our websites. So another couple questions. We've got time for a couple more. Are administrative records in Rule 80B and 80C proceedings to be filed electronically? If so, what if they exceed the size limitation?
Well, at least speaking to the size limitation, Chris, I think Rule 34A1 made to deal with that. It has a size limitation of 50 megabytes. I don't have my ruler with me. I don't know how big that is. However, it says if a document exceeds that, the document itself must be broken down into component parts not exceeding 50 megabytes to absorb it into the system.
Thank you. Let's see, there's a question. Rule 7D, Maureen, did you answer a question? Did you want to do that publicly, or I don't know if that was a question about indigency affidavits?
Sure, someone had asked whether indigency affidavits would be public information in family matters, and it's 7D6 provides that those records would not be public.
Thank you, Maureen. Will the RECS rules be included in the next rules of court? The old-fashioned paper book that I still like. We're going to be including these rules there.
I think we'll certainly take that suggestion back. Thank you.
Let's see, rules. What about forms for Rule 17A, settlement of claims for minor plaintiffs? Are those forms the court is considering? I think it's, question is, yeah, if those are going to be public or non-public.
Those are non-public.
Laura, do you know whether any forms are being considered for that at all?
I haven't heard anything about forms for those, but I think we have Catherine's email. We can contact her.
Okay. Do PDFs have to be in a specific format? And then it says, i.e. PDF/A. I wasn't aware there were different PDF formats. Chris?
There are different PDF formats. So the PDF, I'm forgetting what the A stands for, but I believe the PDF-A format is once it's saved, it can no longer be changed. It's more of an archivable type of PDF format. But the answer is that we will take any PDF type document that you have. Like we talked about earlier, whether it's a scanning of an image or if it's a true PDF document that you've generated and saved on your machine, we'll take those, we'll run them through our optical character recognition and convert those into a text readable format.
Thanks, Chris.
This is Allison Gray. Excuse me, Chris. This is Allison Gray, Court Access Coordinator. I want to reiterate what you, Chris Lewis, had said earlier, that a Word to PDF digital document is ideal for this, but we will take a scanned image because the OCR will convert it to something that is text searchable. But for people that know the distinction, we would certainly like the digital document in its original format.
Good point. Another question, when I file as an attorney and list myself and my legal assistant as the additional e-address, is opposing party required to serve both addresses?
Will, are you able to take that one?
I'm not sure. I'll have to come back on that one. Yeah.
Under another question, under Rule 38B1, in a contract case, when an address used to establish venue contained in a complaint, does that then require the complaint be filed as both a public and a non-public document? Does this require two versions of the physical summons to be filed? Good question.
You mean just Cumberland County, Maine? That would not require redaction. If for some reason the complaint contained an actual residential address, yes.
Because I think that's exactly the question, Your Honor. I think a lot of the complaints get filed in pretty typical civil cases will reference, a street address that a person lives in, just as a matter of course. And I guess the answer may be, rather than a physical address, just say resident of X county versus resident of X street in X county. So. Question, will metadata be removed from a PDF filing that is accessible to the court, to the public in court or remotely? Chris or Will?
Yeah, I'm just processing that question a little bit, Will. So metadata, I'm assuming that's related to the PDF is what's the case number, what's the party's name, what type of filing is it or document is it? And in the accessibility of that data is all governed by RECS in the rules. So if it's available, you'll see that data. If it's not available, you won't see that data.
I think that may have been going to a little different question.
Right.
If I understand it correctly, in a Word document, there's a lot of metadata as to who created the document, when the document was modified, all those sorts of things. And my understanding has always been when you convert it in Word to PDF, I don't know how much that gets pulled over. And I guess that's the question, is whether if you, is any of that data that's associated with a PDF file going to be scraped off by the system, or are you going to have to be aware of that? And there is an ethical opinion on that for attorneys' responsibility for metadata.
I was just going to say that, Chris, I believe that the burden to scrub metadata from a converted PDF is on the attorney. And that's controlled by the decision you just mentioned. I believe it's also in the rules of professional conduct.
I believe so. With that, I think we've gotten through all the questions. If any of the panelists wish to add anything at this point, we're in our last couple minutes here, so we can try to finish on time. We do have a little bit of time, though, if anyone has any closing comments. Okay. Well, then with that, Justice Mead, did you have anything to add?
I was just going to say I had 3 quick things before we wrap up. The first is on the question about the rule book. We missed, Tower Publishing has a cycle. We missed the cycle this year. The rules almost certainly will be included in future renditions, and perhaps even with the enhancements that may occur. So we'll wait until the last minute for that cycle to come around. They will be published. Then I had 3 quick mentions of things that are already mentioned here. There are 3 resources that if folks haven't tapped into already, they've been mentioned. One was the overview presentation. It is certainly worth watching if you haven't seen it. One was the eCourt help email address that I think you already texted to everyone. And then finally, as was mentioned, there will be webinars on the hands-on nuts and bolts, how to run this system, presented by the Tyler folks, who are very experienced and capable in instructing on how to do it. And then finally, I just wanted to, again, express the court's thanks to you and to Steve and the MTLA for putting this on for this platform. We appreciate it. Express my thanks to the panelists for their fabulous presentations here today, very helpful. And then finally, to all the participants, great questions. You've given us lots to think about and things to work on. As I said, it's going to be a continuing process for all of us. So many thanks to all. This is a very worthwhile setting.
Thank you very much. And I appreciate it, all the panelists being here and giving up your time today. I apologize to any participants if I didn't get a chance to ask your question to the panel or I messed it up. So there will be additional presentations in the coming weeks and months, and we look forward to seeing you then. So thank you very much and have a good afternoon.
Okay, bye-bye.
Take care.